And I'd like to now invite our keynote speakers, respondents to the stage. Jaren Unal from Internet Society, Alexandra Wood from Berkman Klein Center for Internet Society at Harvard University, Niels van Dijk, I'm sorry if I'm pronouncing horribly, Center for Law, Science, Technology, Society, Rouge University, Brussels, Aurelia Tamo, Center for Information, Technology, Society, and Law, Erkay Savaş from Sabancı University, with the moderation of Yücel Saygın from Sabancı University. Thank you.
Okay, let's see how to start. I've met I know Erkay, of course. He's a colleague of mine from Sabancı University. And I've met Jaren, Niels, and Aurelia. And I'm just meeting Alessandra now. We have decided this session to be a little bit self-organized, you know. So whoever runs first and starts talking. So, but I think it's better to start with the history. So I think Niels will talk about the history of privacy by design, or give a historical perspective. So, yeah. Yes.
Yeah. Okay. Good. Okay, I am Niels van Dijk of the Free University in Brussels. I will present today some results of a European research project called Candid, in which we looked at smart technologies and the assumptions behind them. And we have a look at what we call right engineering, how to engineer rights in ICT infrastructures. It's based on research with my colleague Alessia Tannas at Brussels University, Kjetil Rommetvedt from Norway at Bergen University, and Charles Raap in Edinburgh. So starting, as we've seen before, with the GDPR and Articles 25 and 35, the introduction of data protection by design and data protection impact assessments. So the whole idea of getting into going upstream in technology development and first assessing the risks that new technologies, ICTs, pose for privacy, and then building the safeguards into the design of the ICTs. So we were intrigued by this, and we set off basically on a research to what we call, with a perhaps difficult word, to sketch the larger network around this idea of privacy design. So to design privacy in ICTs, both historically and empirically. Perhaps as a starting point, it's a life of its own. We could start with a quote by Simon Davies, who already kind of was in the mid-90s, was observing how the field of privacy itself was shifting. In the 70s, privacy was very much dealt with, was seen as a political right, as a civic right, around which people mobilized if they see that there was privacy infringing projects going on. So it dealt with power relations in society, and relations between government and the citizen. But he also observed that in the space of a decade, he said, privacy transformed, and it became framed as a legal right and as a consumer issue. So underpinned by the fair information principles, or the data protection principles. And so this was the kind of the formation of what Colin Bennett has called the community, the epistemic community of data protection, that kind of where different actors from very different backgrounds, regulators, people from the private sector, NGOs, legal scholars, they formed the community around these principles. But what is interesting is that right at the point that Davis is making his comments, so in the mid-90s, we can actually, with hindsight, look at a second transformation that was taking place right at that point. Even in the book where he published his comments, the Agre-Rothenberg book, there's already, we can see a shift away already from these legal, privacy conceived as a legal right, towards an organizational measure or an engineering requirement to be designed in ICTs. And so here we move to what we call the techno-epistemic network of privacy design, and we see different actors on the stage. We have seen this already in the previous talk. I don't have time now to go into all the details, but we sketched out a short history of the important moments in this in privacy design. So starting with PETs, the privacy enhancing technologies, which were very much focused still on the individual, how to come up with a computer science solution for protecting the individual, often through anonymization. Then the move to privacy by design, about which we heard a lot in the previous comment, in the previous talk, with the idea that it's not enough to only come up with a technological solution, but we need a more holistic view focusing on the organizations that run the technologies and look at the whole software lifecycle. This is also where the regulators come in. Then data protection by design now, so this is now introduced as a legal obligation for data controllers, which means that eventually the courts will have to engage with this movement and pronounce judgment on this. And then lastly, the boom in the field of privacy engineering, where software engineers actually engage with this idea of translating these abstract legal principles into engineering requirements. So we started mapping out the kind of the important actors in this field in order to later engage with them through inquiries. And as we see, so this design, it cuts across a lot of different sectors. So it all functions as a kind of a promise, and different people see the benefits of this. So for the policymakers, it helps them in forming the digital single market. It addresses this view that law always lags behind the quick technological development for regulators. It builds trust for products, for companies that can portray themselves as being privacy friendly. And for engineers, it helps them in the work of operationalizing these conceptions. But we must also realize that in this, that we come, the kind of the marriage that is forged here, it's concepts that come from very different, different spheres of knowledge and social organization, where rights are typically articulating according to legal concepts in courts long after a conflict has arisen, so it's retroactively. Here we get into the anticipation. Risk deals with looking at the future and thinking what conflicts could arise, and then working with concepts like probability to see what risks could ensue, and then designing this in the architecture. So if these concepts meet, privacy might perhaps not mean the same thing afterwards anymore. And this is what we set out to research. We did what we call an extended peer consultation, where we, through questionnaires and interviews and a stakeholder panel, we engaged with the actors I just showed on the slide. Shortly I would say, the details are in the paper. But what we found intriguing is the kind of the different, if you would ask the people, they would all talk about privacy in very different ways. So it didn't exactly mean the same thing according to who you were asking and where you were asking the question. To regulators being protected by data controllers, organizations very much looked at it as a risk factor that they could take into their risk management schemes. Engineers, they saw it as what they call a non-functional requirement. And in standardization efforts, it became a kind of the language of building blocks for building infrastructures. So some trends can be taken out of this, I guess. First is a shift away in the focus where privacy at first was focused on the individual, on the autonomy of the individual, also through this idea of privacy-enhancing technologies. And as Anke Vukian said before, this is tied to this concept of informational self-determination in the legal world. But we see a shift actually away from this towards organizations. Organizations through the language of data protection and through their risk management, management methodologies. One gap perhaps to note is that for instance, the GDPR addresses data controllers, the ones who process and set the goals for processing, but not the ones who actually build the technologies, the manufacturers. So this is still, in order to also reach those actors, what we see is increasing efforts in standardization. So with one peer, this is where we engage with the Internet of Things. And there's a huge challenge there because, of course, we don't have a single technology anymore, but we have many different types of technologies that have to start interacting. And these technologies are not made by just one company, but often by many different types of companies. And so there's a huge challenge to make interoperability, but then the complexity, of course, of this effort is huge. So what happens to privacy in this scheme? As one peer said, if privacy is to work, it has to be kind of embedded in all the steps of this infrastructure. So both in the hardware of the things, the Internet of Things, the IoT applications themselves, but also the language, the language that these devices and things would need to communicate with each other. So privacy actually has to be embedded in all those components, and in each of them in a different way. So what happens, as this peer has emphasized, it then becomes what he says is a transversal concern. It's a concern that goes through the whole infrastructure. So we could say that in that sense, then the privacy design it has to be part of this of the ICT networks, which is complex both technologically. It has to follow the build out of these infrastructures, but also socially, because all it has to start being embedded in the work of a lot of people that deal with responsible ICT design. And as we saw, it's not that easy because we have very different concepts of privacy around, and that all have to be aligned in one way or another through these standardized methods, which is at this point a huge challenge. So this was the kind of the first stage of the research, but then we set out that we call this an extended consultation because we also wanted to include people who are not currently included in these networks that are rolling out privacy by design, and which we thought had relevant expertise on both privacy and ICT technologies, and sometimes about the design. So we could think here about ethical hackers, people from the quantified self, privacy NGOs, social scientists dealing with ICT design, legal practitioners, and we even had a judge from the European Court of Human Rights. And in this, what we see is they very much reassert the kind of the older privacy conceptions. The lawyers said the privacy is really seen as a human right, and the civic actors where it has to be seen as a public and political freedom. And so at the start of the talk, when I talked about Simon Davies, these are the conceptions that we could say they return to. But if we include this in this broader view, we actually see a whole set of tensions that start to arise that are not so easily accommodated, perhaps. First, relating to what is this concept of privacy that is to be designed in the technologies, because according to the concept we use, it has implications for the scope of design. And what we see here is this tension between the focus on the individual, the idea we heard before about control, giving the individual control and enabling autonomy, or a design that is, and which was, for instance, in line with pets, but also people from the quantified self reasserting this, or more systemic designs that focus on the design of the whole system with data controllers. Perhaps, and this is where we get to the fact that we moved away from individuals to organizations, and now from organizations to infrastructures, we increase complexity. And this complexity makes it difficult. It makes these things an engineering challenge. And what we got from our consultations is that this engineering challenge is so great that it actually leaves little space for negotiating different conceptions of what type of privacy should feed into these exercises, little space for instance, public consultations. So that was also seen by some of these peers as a problem. Third, the gap that is still very much exists between the legal dimension and the engineering dimension. It's what we call the Rubicon that is still not crossed in this case. Legal rights are generally very abstract level. They are ambiguous, open for multiple interpretations. They come with all kinds of exceptions. They have to be weighed against other rights and interests. Whereas the engineering reality, it requires unambiguous language that can be formalized mathematically. So between, that gap was still quite big, and so it opens up a space in between for other translations between the two. And this is often where you see people jumping in to provide those translations, like often in privacy design strategies, targeting the managers in these processes. Lastly, and perhaps most critically, were the NGOs. They saw some dangers in these design approaches in the language of what we could call blue washing. They were afraid that if these design approaches were followed and very minimalistically, that people could say, look, we're now very privacy friendly, but in reality it's very minimal, that this would kind of give a privacy friendly image, but at the same hand preempt the types of mobilizations of people against these projects that have been successful in the past. So this was seen as a danger for them. Wrapping up, so we chose this title, right engineering, because of its double meaning. We can say privacy starts to play an increasingly important role in the design of ICT technologies, but in this very process, it is itself redesigned. So what privacy starts to mean in building this in, it starts to mean different things, and different things for different people involved. So in this study, what we've tried to do is map this out, map these broader networks out, bring them together to discuss these issues, but also extend these networks to other actors with relevant knowledges to map out the tensions and perhaps also the directions for the lessons that can be learned about what type of privacy we want to be embedded in these technologies. Thank you.
Okay, we can have a few questions, I guess. Yeah, I would prefer to have questions before the audience forgets what you have talked about. Any questions? If there are no questions, I'll have one. So privacy by design is always an abstract concept for me. I mean, there are principles which Anka Vukyan described very well because she came up with them. And as an engineer, I'm always interested in more concrete, because I work with algorithms, there's the input, here's the output, here are the standards. Let's say I'm designing some specific technology and variable device which collects my health information and stores it in the cloud. What can I get from your talk? What can you advise, or how can I project your talk into my application or business?
Well, like directly, I mean, this is more, it's an observation on the field. So I guess what it's primarily showing is exactly this. It's the difficulty, because of course you have all these. We saw it with Anka Vukyan as well, trying to operationalize. So we have Enisa, we have Anka Vukyan. In order to bridge this gap between these abstract legal principles and the engineering reality. Mm-hmm. But what this study shows, it's exactly this, that at this point it's still quite difficult, because there's different visions of what has to be designed, also within the privacy by design, mm-hmm. as some call it focus more on the policies, mm-hmm. Other focus more, as you say, on certain anonymization techniques. Yeah, in that sense, okay. Yeah?
I get it.
Okay.
So what I get is that there's a long bridge between privacy by design and the engineers, or we need to have lots of more conferences like this, I think, involving engineers, scientists, as well as lawyers. So I will ask the same question to all of you, except Erkay, so be prepared. So we can go on with the next talk.
Is it on? Awesome, thank you. So thank you, Niels, for your really interesting presentation on the historic overview of privacy by design. It's interesting because my talk really builds upon your last question that you put out there, what scope, how to implement then privacy by design. So I'm gonna really look only at Article 25 of the GDPR, and how this principle of privacy by design, as is codified in there, how to implement that. So to start, I would like to motivate this talk with a quick case study. Just think of, for instance, a startup that sells, that wants to make it in the IoT market and sells a wearable device that is like a tracker to just track your sleep. So the question for this startup company is all right, how am I compliant with Article 25 of the GDPR? And when you just look at the GDPR, it's actually not really a straightforward norm. So the norm itself is kind of hollow and doesn't contain much information on how to do so. It literally refers back to just implementing appropriate technical and organizational measures that meet all the requirements of the regulation. And so already before there was this Article 25, Daniel Soloff said that privacy by design is like a cupcake without a recipe, and this is a pancake recipe. Well, actually, it's hardly a pancake recipe, but the idea behind the slide being, yes, we need to provide some sort of building blocks to developers and engineers in order to be able to implement this principle. And so the building blocks, or I see 3 building blocks. Well, of course, first, we have to understand the legal principles and their protection aim. Secondly, we have to classify the technical and organizational measures that exist, that can actually be implemented. And then we have to look at the GDPR, but also other maybe more sector-specific regulation that provide guidelines to data controllers, developers, and engineers in turn on how to then implement those tools. So let me just quickly go through these building blocks. The first being the legal principles. I divide them into 4 categories: principles concerning the legality, principles concerning the design, individual rights, and compliance and enforcement tools. So the legality principles are very much the core of the GDPR. Included here is lawful, fair, and transparent processing, or legitimizing the processing through either informed consent, as flawed as this principle is, or just legitimate business or public interest. The principles concerning the design build kind of the framework in which engineers and developers can innovate. Principles here are, for instance, data minimization or securing data processing, but also limitation on how to use, disclose, or store the data. Individual rights are pull rights, meaning that the data subject, him or herself, has to ask for access to the data or object to a certain processing operation, or then ask for his or her data to be erased. And finally, the compliance principles are kind of what motivate data controllers to actually implement the principle I just mentioned, through sanctions and supervision of data protection authorities. The idea is that, well, then these principles are going to be adhered to. The second building blocks being the technical tools, and here we've already talked about security tool, or Kevukin already talked about security tools. Other tools that exist are anonymity tools, autonomy tools, and transparency tools. And it's often, to be honest, security and anonymity are intuitively linked to privacy by design, but we have to look at the whole toolbox of potential options. So security tools, since we already talked a lot about that in the keynote, yes, cryptographic measures come to mind, securing the communication architectures, but also defining who is authorized within a company to access what data. Anonymity tools, and anonymity here being the inability to sufficiently identify a data subject from a set of subjects. Here we have different options like generalization, randomization techniques, or also the creation of multiple identities. And obfuscating communication paths through proxies or mixed networks. Autonomy tools then are much more tools that provide some sort of control to the data subject on who has access and what the controller can actually do with that data. Other tools here are also disposal control tools, through personal data stores, for instance, or controlling how and when the data is being deleted. And finally, we have transparency tools that provide some sort of information about how the data is being processed. A typical tool here are just like visualization efforts, like privacy icons that provide some insights on how the data is being processed. Also internal, like organizational measures, such as like privacy impact assessment that are like internally just for internal use, or notice procedure are other tools that fall within this category. Thanks, I have. Thank you very much. I think I should drink. That was the cue. All right, and so the last building block is how can we find guidelines on how to apply privacy by design? And here we have to look at, of course, Article 25, but then also all the other principles within the GDPR, as well as looking at more sector-specific rules on how to apply those tools. And so I'm just going to say just a few things. It's interesting here to note that when you look at the law, the law can be actually quite specific. For instance, when it comes to security tools, the law says which risks these tools have to address. So that makes it much easier for a developer to then like address those specific risks with very specific tools. And then in other fields, for instance, when it comes to anonymity, the law is a bit less clear-cut. Another thing I want to point out here is that it's important to note that within Article 25 itself, you can see that the privacy by design is not like an absolute. So the article says that you have to strike a balance between like the cost of these tools, you have to look at the context in which they are implemented, and the risks that are associated with particular processing practices, and that there must be a balance between like full privacy by design and like these other factors, like balancing these conflicting interests. All right, so let's get back to the case study that I mentioned before. And actually, as was mentioned in the keynote, and also by Niels, it's important to look at the whole life cycle of data. And so in this slide, you see a data subject in the middle. I call her Alice, that has a wearable device and a smartphone. Well, the wearable device connects over Bluetooth to the smartphone, and then the smartphone transmits the data to the cloud. And then in the analysis phase, you see two databases, as there is like one database for the health data, like the sensor data, and another database that has her like login information and more like the identity database, that's how I call it. Then in the implementation phase, the aggregated data is visualized back to Alice on her smartphone, and finally in the erasure phase, she can decide if she wants to delete the data. So let's look at the transmission and the collection and transmission phase. Here you have different tools that you can implement. So for instance, Alice does not really need to register with her full name. She can also just use a username, making it more pseudonymous. You can reduce the amount of data you collect if like the full birth date is not necessary, but just the year of birth is enough for your analysis, then that's what you should do. Of course, she has to consent to transparent terms of processing, and here actually the GDPR is now much more specific on what transparency meaning it tells the data controller what information he or she should provide. And then the communication among devices has to be secured. In the analysis phase, there is on the first step, the company has to choose which external service provider to use, like Amazon and Microsoft come to mind, but it's important to like decide on that and know why you decided on a specific provider. The splitting of database helps working towards security and anonymity. Different authorization levels have to be established, so that who has access to what kind of database and why and how so. And then internal guidelines on those procedures have to be established. In the implementation phase, we have on the one hand side more technical tools like separation controls that ensure that data is only used for the purposes that Alice consented to. Then we have also more like organizational measures, like internal ones, such as handling restrictions or data breach notification schemes so that employees know what to do. There are also like transparency tools, like visualizing how the data is being used. And the new right of data portability should allow for allies to be able to download the data. Finally, in the erasure phase, we have also here technical tools such as security lesion mechanism that ensure that data is not only like overwritten, but actually deleted at all layers. And then we have more like organizational measures such as guidelines for retention and backups, but also like guidelines on how to deal with data subjects' requests for erasure. So very quickly, what are the key takeaways from this case study? Well, first of all, we have to understand the guidance that is provided within the law. Secondly, it's really important that we understand the data flows between employees, but also among devices. And third, and also as the keynote pointed out, the context is very important. You have to look at the risk in a specific context and then prioritize your actions accordingly. And so I know this was very fast, and I'm sorry for the self-promotion at the end, but I literally wrote a book on this subject. And so if you have further questions, you can ask me. I'm here the whole day, or not, you can just look at the book. Thank you very much for listening.
So I guess we are going from more philosophical and abstract to more technical, more concrete, which is a good thing, you know. We have, huh? That was the goal, yeah, that was the goal of self-organization.
Yes.
But I have a question before you go. But maybe there are questions from the audience. Ah, yes, excellent.
Great, thanks so much, and thanks for both presenters, and the question is for both presenters as well, which, by the way, the presentations were brilliant. I thought it was really well done. And so the question is with regard to then the governance questions of applying privacy by design or applying privacy provisions. And so a lot has been done around the role of chief privacy officers, for instance. And so the question is, what do you see the role of chief privacy officers to be within the context of privacy by design, trying to mediate the technical requirements and then also the legal or even the human rights requirements? And so do you see that role to be adequate, or do you see actually the need for new roles to emerge that can actually expand the concept of chief privacy officers?
Niels, do you want to go first, or should I go first? Yeah, I mean, well, I think chief privacy officers are for sure very important. I was looking at a more startup scenario where you will probably not have a person in charge just for privacy and data protection. And so there, I think, it should be on a more employee level that there is this awareness. And to do so, that's why I looked at breaking this down to the smallest ingredient as possible, that it becomes very clear. Also for just an engineer just working on a given subject, on how to implement that. But yes, I think that the role of chief privacy officers is important, and there is a great book on that by Mulligan and King, I think, that also says explains on what level these chief privacy officers should be integrated within a company in order to actually make a meaningful impact on then how the structure is then designed.
Yeah, to tie in with that, indeed, it relates very much to the idea of accountability. So the principle of accountability and the role of the privacy officer is crucial there. What we saw in the case study, and it relates to what you say as well, is the kind of course, these are principles that have to be applied to all companies, but there's very much a difference between the big companies and the startups. And with the startups, what you see is they had so many other risks that they had to manage already, that privacy was very low. And the main thing was keeping the company alive for the next 2 years. And then so there was a lot of different, according to what type of company you were speaking to, they had a very different position on the role of these officers here. No, but I definitely think that that the role of the privacy officer is very important. It's also a big challenge because a lot of people will have to be hired now and have to be trained. So it's a huge undertaking. So yeah.
Okay. I'll skip. I'll not ask my question now. Maybe later on if we have time, so we can go on with the next talk. Unless there are questions from the audience, we have one.
Yeah, I think I have a more general question for the entire panel, so others can think about it already. But it's also addressing Niels and Aurelia. Sorry. So, how do you see the relation between privacy by design and, let's say, the purpose of applications, and the wider sort of obligations in the GDPR? And just a little bit of background. A year ago, we had a workshop on privacy by design, and we were toying with this Google Glass-like application for law enforcement. Right, so you see this officer Judy, as we called her, walking around, and she got information projected about the scenes that she was visiting, and we were tasked with coming up with privacy by design solutions within that scenario. And of course, you can blur faces and what have you, and not give out information when unnecessary, etc. We can all do that. But on second thought, the entire scenario was kind of horrible. I mean, the whole so. We came to the conclusion that yes, you can apply privacy by design in this context, but it's merely a fig leaf for a horrible application. So, and Niels touched upon that a little bit. But so how do you see that? And all panelists maybe later on. What do you mean by horrible application? The amount of information. So I mean, the police officer is so the scenario was domestic violence. So she is called into to a situation which is potentially about domestic violence, but there are other people in the room, and she inevitably gets to see more information than necessary for handling the situation, and therefore, especially the privacy of people not associated to the domestic violence are revealed to this police officer that she has no business with. And so it's incredibly difficult to confine the information to the task at hand, and therefore and then as soon as she tilts her head somewhere else, then she will get to see information about people that she shouldn't see, basically. So that's what I mean with I mean, it's slightly more complicated, but the whole scenario is sort of panoptic surveillance kind of thing that also Anke touched upon.
Should we answer now or at the end? Yeah?
At the end or now?
Up to the self-organizing panel.
Okay. Well, maybe. Well, I'm not sure if it's. I will try to come up with a short answer, but indeed, I think that's. Yeah. Maybe a short answer now. Yeah. Sure. Okay. So I guess this ties into that discussion on the last point, the concern of what is the broader implication of doing this. So if as you say, can you have these technologies, they make a lot possible, and so certain of these the things they make possible with data collection, you don't know at the point in time itself, and it becomes clear later. But you have done in advance kind of a privacy by design clearance. So then it helps you in actually furthering in the introduction of these devices, whereas the original question perhaps should have been, what kind of devices do we need for law enforcement in the first place? And so I think that those are broader questions, and we should be careful that that kind of the privacy by design doesn't further those kind of schemes.
Yeah, I mean, I think so too. I think what you're asking is definitely beyond the scope of what privacy by design as codified within the law now wants to actually entail, because you kind of, what you're looking at is what is a correct like decision-making standard for like how we apply technology, which, you know, like comes at the very beginning, I would agree, but probably hasn't been done so far, and it's not what we have in the law, but it's a very interesting question to ponder on, but I don't think the law wanted to kind of address that.
Just shortly, your question reminded me of I've been reading more and more about human rights by design. So human rights concerns being embedded in the technology, but the developments are not very promising. I think it was last week, European Court of Justice issued a judgment calling that access to phone data for non-serious crimes are also acceptable. So it was interesting. Maybe we can discuss this further on in the end.
Sure. Thank you. It's a pleasure to speak this morning about ongoing interdisciplinary research to understand the state of the art for privacy protection and how to integrate this understanding into the design of a modern data protection program. I'll begin by making some observations about the current big data landscape in which corporations and governments are collecting greater quantities of personal data at finer levels of granularity. They're collecting data at more frequent intervals, and they're collecting, storing, and using personal data for longer periods of time. These activities create opportunities for research, for policy making, for making business decisions and providing services to consumers and constituents. However, they also increase identifiability and expand the range of harms to which individuals are exposed, thereby putting pressure on traditional approaches to protecting privacy. And the trends that we see now in the big data era pose numerous challenges for protecting data. There are variations in contextual factors in each use case, and the privacy approaches may require time-consuming case-by-case review and negotiation processes that result in markedly different treatment. In some cases, the same data set held by two different organizations would be treated drastically differently. And we're now seeing that current practices are in many cases inadequate. Common approaches such as de-identification and notice and consent are increasingly being shown to fail to provide reasonable protection. And we're also seeing reduced utility. Data are heavily redacted or withheld altogether due to privacy concerns. And this leads to overly restricting access to data and limiting future analyses on the data. And in particular, advances in the scientific understanding of privacy have demonstrated that widely used privacy approaches that rely on de-identification and anonymization techniques fail to protect privacy and don't provide reasonable protection that individuals expect. Traditional approaches to privacy, such as de-identification, address only a subset of privacy attacks and attackers. We now understand that there are many types of privacy attacks that were unanticipated by some of the early de-identification techniques. Traditional techniques are also not readily scalable for use by non-experts. They often require people with training and expertise in de-identification technologies in order to apply these tools. And they have to conduct a comprehensive risk analysis and identify different types of information that could be used in an attack, publicly available information that could be leveraged in an attack. And this often results in the redaction or withholding of useful information. Traditional approaches to protecting privacy are therefore not well suited to address privacy risks in the era of big data. What we observe, and this is a is that the risk factors of long-term data collection change the surface of suitable privacy controls. Although businesses and governments often rely on a narrow set of privacy controls, such as notice and consent mechanisms and de-identification or anonymization techniques, these are inadequate to protect personal data. However, the research community has developed rigorous risk-benefit analyses and best practices, and these practices can be instructive for privacy management in other settings, such as corporate or government contexts. Specifically, researchers who conduct long-term studies are governed by strict ethical and legal frameworks and oversight by an institutional review board. And they incorporate multiple layers of protection, including explicit consent, systematic design and review, statistical disclosure control, and legal and procedural controls. The text of the GDPR explicitly recognizes the need to take such a holistic view of data protection. Specifically, it requires data controllers to take into account the state of the art, to consider the nature, scope, context, and purposes of processing, to take into account the risks of varying likelihood and severity for rights and freedoms of natural persons, to implement appropriate technical and organizational measures, which are designed to implement data protection principles, and to do so in a way that integrates the necessary safeguards into the processing. And so to address the question for this panel, how do you operationalize these requirements? We've been developing what we call a framework for a modern privacy analysis, which is modeled on approaches from the information security literature and builds on life cycle frameworks for data management. And it involves developing a catalog of privacy controls. So instead of looking to a narrow subset of privacy controls like notice and consent or de-identification, we recommend drawing from a broader range of possible privacy controls that are emerging from legal, economic, and computer science, statistics literatures. We recommend identifying information uses, threats, and vulnerabilities that are applicable in a given use case. So what are the intended uses of the data, and what risks do uses of the data pose to the individual data subjects? And third, we recommend designing data releases by aligning uses and risks with controls at each stage of the information life cycle. And we've developed a catalog of privacy controls. We've looked at various procedural, technical, educational, economic, and legal means for enhancing privacy at each stage of the information lifecycle. Here's a snapshot looking at various tools that are available when making a decision to provide access to the data or to release the data to a third party. There are procedural controls like access controls, consent requirements. There are economic controls like access and use fees and property rights. There are educational controls like data asset registers and transparency tools. There are legal tools. There are a range of different tools. There are tools for redacting identifiers from the data, for applying heuristic disclosure limitation techniques, and tools for robust disclosure limitations, such as secure multi-party computation and differentially private statistics. And if what you're concerned about is the harms that can result from use of the data, then you may look to combine controls that focus on sensitivity. So secure data enclaves with auditing procedures could be used to control how the data are analyzed and used. And in some cases, secure multi-party computation, computable policies, or personal data stores can fulfill similar functions. Formal application and review by an ethics board prior to access and use of the data can also be used to address these concerns. And notice consent in terms of service and personal data stores, blockchain tools, and privacy icons, or other options to address these types of risks. And here we provide a diagram that shows the relationship between the identifiability of data after it's been transformed by redaction, by a heuristic disclosure limitation technique or a formal disclosure limitation technique, and its relationship to the level of expected harm from uncontrolled use, ranging from negligible harm to life-threatening harm. And if you look at these two factors, they point to various controls that would be suitable given the identifiability and the risk of harm. For example, if you're using rigorous statistical disclosure limitation techniques like differential privacy and the harm is negligible or minor, then it's possible to share the data in the clear without additional controls because the risk of harm is low and the controls provide strong protections against identification. But if all that's been applied is a simple redaction tool, then the risk of identification is high, and if the risk of harm is even negligible or through life-threatening, then additional controls should be applied, whether that's notice and consent, where the level of harm is minimal, or formal application and oversight by an institutional review board, or even secure data enclaves and immutable audit logs, where the risk of harm is high. And we see in the big data era that factors such as increasing the frequency of data collection or collecting data over a longer period of time put pressure on the situation and would counsel towards providing stronger protections. It shifts your position within this diagram outward. And here's another way of thinking about the intended uses of information and the big data risk factors. For example, if the intended mode of analysis is at the population level, then tools like differential privacy and terms of service and secure data enclaves may be appropriate given the different risk factors involved. But if you're looking to perform individual analytics, something like differential privacy wouldn't be an appropriate solution, but something like personal data stores or blockchain audit logs, secure multi-party computation may be appropriate solutions. So how do you integrate all of these various safeguards into a data processing program? One of our primary recommendations is to use tiered access. In light of the limitations of traditional de-identification techniques, practitioners may consider conducting a systematic analysis of informational risks and intended uses and implement a combination of privacy and security controls rather than relying solely on a single technique like de-identification. A tiered access model can closely match combinations of privacy controls to different risks and intended uses at each stage of the information lifecycle and bring gains in both privacy and utility for a broad range of uses across different types of data. And here's an example of a tiered access model where you have the data holder who provides data to a repository or some other type of curator who mediates access to the data. You provide open query access. This is the most open option using differentially private tools. can allow a user to download the data after the data have been sanitized and under the terms of terms of service. The repository can allow download with approval under the terms of a data use agreement, or for the most sensitive data, or the most sensitive view of the data, the repository could allow access via a protected analysis in a secure data enclave. And the Privacy Tools project at Harvard has implemented a tiered access model through the Harvard Dataverse. It's a social science repository where researchers all over the world deposit data, and they're made available through this platform. And the vision of the Privacy Tools project is to build an array of computational legal policy tools that make privacy protective data sharing easier for researchers without expertise in privacy law, computer science, and statistics. We have tools that we call robot lawyers that automate data sharing decisions and generate custom data sharing licenses using logic programming to develop a custom data sharing agreement that contains all the elements required by law or policy. And we also offer tools for making data available using differential privacy. Differential privacy provides statistical summaries, and these tools allow exploratory data analysis with strong privacy guarantees. So this is a way of making some analyses on the data available to the general public. Doesn't require an application or data use agreement in order to access the differentially private statistics. But where a researcher wants to access the raw data, then they can go through the approval process and agree to the terms of a data use agreement. And we've also been developing tools for exploring the relationship between privacy technologies and the law. How do you argue that an emerging technology like differential privacy is sufficient to comply with legal standards for privacy protection? So in conclusion, the modern approach to data protection recommends calibrating privacy and security controls to the intended uses and privacy risks associated with the data, taking into account not just re-identification risks, but also inference risks, using a combination of privacy and security controls rather than relying on a single control, such as consent or de-identification, considering newly emerging advanced data sharing models like differential privacy, anticipating, regulating, monitoring, and reviewing interactions with data across all stages of the life cycle, not just looking at the data release stage, but also considering post-access stages, and emphasizing the need to provide similar levels of protection to uses that pose similar risks, regardless of the use case.
Okay, thanks a lot. Again, one more brilliant talk. Thank you. We will not take questions at this point. At the end of the panel, maybe we'll have time for a few questions. Erkay promised me to have his talk in 10 minutes, so we'll not be behind schedule that much. Thanks again.
Hello. There is a caveat for this talk. I'm an engineer, cryptographic engineer, so this is going to be technical talk. I'm from Sabancı University, and I'm going to show you the interaction between cryptography and privacy by design, how we can utilize cryptography to implement privacy by design, principles. All right, so these are the 7 privacy by design principles, and keynote speaker talked about this. And I looked at them, it's really difficult to implement all these things, sky is the limit here, because I'm an engineer. I'm just thinking, how am I going to implement it? Okay? But let me say one thing about cryptography, because when people talk about cryptography, always think about encryption. I mean, I have to correct this. Cryptography is not just encryption. You know, cryptography provides a very, very rich, esoteric, exotic set of different functionalities that you can utilize to implement. As the previous speaker talked about secure multi-party computation, homomorphic encryption, functional encryption, attribute-based encryption, all these things are really, really important, and I'm just doing research on these things, okay? So let's take a look at the principles. The first one is a proactive, not reactive, preventive, not remedial. All right, so we should not wait for privacy risk to materialize. This is what it means, right? But of course, cryptography requires serious planning. We need to identify the risk, devise a protection mechanism, and utilize cryptographic tools to implement them, like encryption of data, authentication, authorization, and etc. And in fact, cryptography does not usually offer a remedy. Once the privacy and security is lost, it is lost, right? Cryptography really cannot help it. But cryptography, basically offer you several concepts like forward secrecy and backward secrecy. For example, I mean, if you lose your, privacy or security in the future, this is not going to affect your past, for example. These concepts may be relevant for you. All right, privacy as a default setting, well, if an individual does nothing, her privacy still remains intact, all right? If it is to be default setting, then protection mechanisms must be implemented by default. I mean, for example, user data is always encrypted. Access control enforced by cryptographic tools. Identification, authentication, authorization, integrity, all of them should be there. And of course, there are different ways of identifying a person. You don't really have to identify a person, by its name, by everything about him. I'm just identify his or her role, right? So cryptography provides these tools. The third one is that privacy embedded into design. Well, privacy is integral to the system without adverse effect on functionality. Data are collected, stored, processed to extract useful information. This, however, increase the severity of security and privacy issues. And as you see that, the data often contains personal and sensitive data. And besides, the other well-known tools, cryptography provides us with the primitives that allow processing data without violating the privacy of individual. I'm going to talk about, one particular field, which is called homomorphic encryption. This is the area that I have some expertise. Well, again, this is the same thing, full functionality, positive sum, not zero sum, right? I mean, so this means that we should not, basically put privacy versus functionality, privacy versus security type of thing, right? So we can have it both, all right? For example, if you use, homomorphic encryption, private information retrieval, secure multi-party computation, you can have it both, right? You can just utilize and the data to get useful information, but still, keep the individual's privacy intact without violating it, all right? So, for example, you can have what is called aggregate processing, over encryption. And visibility and transparency, okay, so all right, so the data subject is made fully aware of the personal data being collected and for what purpose. So we can basically have mechanism, and a user can privately query a database if her personal data is being kept, right? I mean, you don't really have to identify yourself whether you can, query this data, all right? And we can even provide proofs, cryptographic proofs that the personal data is being properly managed and handled. And what we can do further for transparency's sake, we can keep these proofs in a public ledger like blockchain, right? I mean, so people are proposing, and for example, a company can basically apply those best practices for privacy and, keep the logs and control who's accessing all these logs and everything, or this data. So we can just keep them in a public blockchain, and everybody can see whether this, company is, doing what it is claiming to do. All right, the last one is the respect for user privacy, keep it user-centric. We can inform the users they have the option for strong privacy defaults. All right, and so therefore they can remain a player in the system without sacrificing their privacy, okay? And we can empower them with their privacy-preserving options that can be implemented, fully implemented, if you have those cryptographic tools at hand. All right, so I'm going to talk about, it's going to be a little bit more technical. I'm going to talk about, I promise you that I'm going to talk about the homomorphic encryption. All right, so what is an homomorphic encryption? Computation over a ciphertext or encrypted data without decrypting it, without seeing what is inside, without decrypting. You don't need to have the secret key to decrypt and see inside. Okay, let's say simple thing. Let's assume that we have two messages, M1 and M2, and the encrypted forms, but this is a specific form of encryption, right? It's not just, you know, classical encryption. So E of M1 and E of M2, they are ciphertext corresponding to this text. What we can do here is that we can basically perform several arithmetic operations or logical operations so that, you know, the result, I mean, you can just doing addition and multiplication here without seeing this data, okay? And another, for example, this is something we are working on. For example, you can compare two numbers, which one is larger? And we can basically create an encryption of a larger number, all right? So of course you can just think that these are just simple toys, but we can utilize them to build really, really complicated, you know, the mechanism to protect privacy. For example, this is something I'm working on it, which is kind of, you know, related to what is called targeted surveillance. I'm working on cybersecurity, but I have a name for it, privacy-preserving cybersecurity, all right? So let's assume that we have some threat model like, you know, it's a simple one, just a toy example. It's an overly simplified example. Well, for example, if a protocol is at TCP and if its duration is more than 330 seconds, well, let's assume that this is a threat. So you are looking for this to happen, all right? So this is what you do, all right? So that you can just come up with what's called a Boolean formula, right? Threat is equal to 1 minus x1 times x2, all right? So this is what you can do, all right? So you can just compute the encrypted version of, version of a threat without seeing what's inside. That's interesting, right? I mean, we don't need to really have to know actual values. When the threat happens, you know, that will be alarm, right? You don't really need to see whether it's 500 seconds or, you know, or 1,000 seconds. I mean, exact formula. You can just do that. This is the homomorphic encryption operation. All right, so I think we are now seeing some sort of a cryptographic revolution, right? So there is an unprecedented interest in cryptography and its due importance in many applications. And probably I'm kind of, I regret to say this because this is due to the blockchain and Bitcoin, because, you know, people are talking about cryptocurrencies, and I hate that term, by the way, because cryptography is a cryptography and it has nothing to do with cryptocurrency. I don't want to have that association. All right, but, you know, this is a fact because people got interested in that. All right, so why? The reason being is that new technologies, because of the cyber attacks, mobile devices, smartphones, and all this new cloud computing, you know, this is only increasing the privacy problem, all right? And also blockchain, right? So, I mean, the blockchain is a very good example of, you know, what you can do with the cryptography, okay? You know, because blockchain is an amazing technology. Everybody got interested in that. But, you know, blockchain is using as two simple, you know, cryptographic primitives. One is cryptographic hash. It's like, I don't know how many years we know it, and we know it very well. And digital signatures, very simple, very straightforward, very classical, you know, application of cryptography. And you can do amazing things with this cryptographic, simple cryptography. I'm amazing myself as a cryptographer. I mean, it's a very imaginative way of using, you know, cryptography in different, you know, places. So my, you know, takeaway here is that cryptography is the enabler for privacy, you know, implementing for privacy by design principle. And you have to really, you know, realize that there's a rich set of primitives in cryptography, all right? And if the blockchain guys can understand the cryptography and privacy by design, you know, community can understand these, you know, very advanced esoteric, exotic, you know, functions of cryptographic functions, because they are really, you know, interesting to use. Okay, so well, that's it. I'm gonna conclude here. So, I mean, thank you very much.
Thank you, Archive. You are really very much on time. I have a title for your research, Private Cybersecurity by Design, because now everything is by design, so private cybersecurity by design. Right. Now we have an explanation, we have trust by design, right? Great. So we'll have the questions later on, if we have time.
Good morning, everyone. It's almost noon, but I'll try to keep it really compact in order to save time and to make sure that you have your much-deserved coffee soon. I'm working for Internet Society. Just a few words. Internet Society is a global non-for-profit organization founded by the founding fathers of the TCP/IP protocol, Windsurf Bobcan in 1992. So just like ICANN, we've been around for quite some time in the internet governance scene. And we are working for an open, globally connected, secure, and trustworthy internet for everyone. So we've been working on trust and access issues for quite some time, and today I'm going to share a campaign that we recently launched called Trust by Design, and I was really happy that it came up in the keynote yesterday, because trust is a broader term which encompasses security, privacy, ethical data handling, and most importantly, user confidence in the internet ecosystem. We have various chapters around the world. We have global members, we have regional offices, and I'm working for the European Bureau, which is based in Brussels. So, as I said earlier, we recently, this year, by the beginning of this year, informed by our annual Global Internet Report focusing on the future of the internet, we decided to launch a campaign specifically focusing on consumer-grade IoT devices, because our community informed us that it is quite a vulnerable area. And IoT, especially consumer IoT, when I'm talking about IoT, it's not just connected devices connected to the internet, but a network of devices acting in a coordinated fashion and being automated, controlled, and communicated over the internet. And I'm using connected devices instead of smart devices because, as you also know, some of the devices are pretty dumb, and worse, they talk to each other about us behind our back. So building trust in such a complex ecosystem is only defined by its weakest link. So device security may not necessarily be that weakest link or the most effective means of addressing the security problem. So to obtain trust, we cannot isolate privacy from security. So building trust in consumer IoT in particular is most effective when it is part of the design process from the start. Privacy and security by design, in other words, trust by design. It is much more difficult if you try to do it as a bolt-on to be added later, and also more expensive. So I love Ankavukian term, privacy by disaster. It's very accurate. So now currently we have more devices than people. By 2020, estimates are between 20 billion to 50 billion devices. As more and more devices are connected, privacy and security risks are on the rise. Speaking of some figures, 59 of IoT devices failed to adequately explain customers how their personal information was collected, used, and disclosed. 72% failed to explain how customers could delete their information from the device. 38% failed to include easily identifiable contact details if customers had privacy concerns. So these are all issues related to GDPR compliance as well. And during the campaign process, both planning and implementation, we realized, because we also have an initiative called Online Trust Alliance, which built a framework called IoT Trust Framework, embodies all the 7 main principles. During the campaign implementation, we realized GDPR entering into force was a huge catalyst, at least to raise awareness, and a positive side effect. Implementation of the framework that we're trying to advocate for is also quite helpful for GDPR compliance, so we were really pleasantly surprised there. I mean, not that surprised, but pleasant mostly. At first, I thought about giving all these examples bit by bit, but you're already familiar. So many of today's IoT products and services in the consumer market are rushed to the market at the lowest possible cost, with little consideration to basic security and privacy protections. IoT devices, by their nature, they do not tend to rely on graphical user interfaces, like a phone or a laptop, as we're accustomed to. So where alerting a customer is quite straightforward. This creates a big challenge for GDPR compliance as well. How are you going to implement right to be forgotten? How are you going to implement privacy by design by default when it comes to IoT? Because you really don't know how to access the user interface, and it is convenient, and for convenience, most users, including myself, I should say, I hate to admit it, but we compromise for the sake of convenience. More headlines. So IoT use cases that rely on data processing and analytics in the cloud will have a difficult time ensuring compliance. The interaction between the device and the data is far from simple. It involves numerous parties, and responsibility for the data extends across the whole supply chain. The upcoming e-communications privacy regulation is going to address this in a complementary manner to the GDPR, but also there are several concerns, especially whether machine-to-machine, non-personal data will also be subject to the regulation, but that's a different discussion. So what type of risks are we talking about? A connected world offers the promise of convenience, efficiency, but creates a platform of shared risk. We have a wide variety of risks, from just mere annoying bugs, from some creepy occasions, to some really dangerous life or health-threatening risks. We might have unlocked doors, turned on cameras, shutting down critical systems, and theft of personal property. So people's safety or the safety of their family might be even at risk. Large IoT-based attacks recently, especially such as the Mirai botnet in 2016, have crippled global access to high-profile internet services for several hours, which is a long time in the internet world, as you as well know. We are facing two types of risks. If you follow an inward approach, inward risks are focusing on the potential harm to the health, safety, and privacy of device users and their property. From an outward perspective, there are also potential harms that compromised devices and systems can inflict on the internet and other users. So making this distinction is not always that easy, but as internet society, our focus is on the impact that IoT security and privacy has on the internet and other users in the whole ecosystem. We have new devices, we have new vulnerabilities. After Roland's presentation, I was inspired to include a cat pic, at least one. This is an imaginary cat robot. It's not a real device, but they're meowing to each other. So we have a bunch of new risks created by these new devices and new challenges. We have cost concerns, the mass volume of identical devices, limited user interfaces, embedded devices, unintended uses. We have a new acronym, as if we needed more of them. Bring your own IoT. It's like bring your kid to the office. It's a new thing. So apparently, some businesses are encouraging employees to bring their own IoT devices to the office and use them for their everyday business operations. But this creates a whole new bunch of risks. We set the scene, we know the risks, we're aware. I don't want to spread paranoia. But who is going to solve this? Again, a question with regard to implementation. We know how to address, but who is going to solve this? We are in extreme need of a collaborative solution, because I know I'm going to drop the M word, multi-stakeholderism. I always make the same joke. It's like saying multi-stakeholderism in an internet-related event is like saying world peace in a B2 pageant, but it doesn't make it less important. So we have plenty of actors, we have plenty of players in the field, and in order to provide and ensure a secure and private IoT, developers, users, policymakers, technical community, they all have to come together and have a work collectively, because if you look at from the roots of the internet, that's how the internet works. Internet is a global, interdependent network of networks. So collaboration is in its essence. So it's just like speaking about multi-stakeholderism for the sake of nicety, being nice and just saying it for the sake of saying it. It is a necessity. We have to work together. We have to build consensus. It has to be collaborative. We have plenty of challenges. We have economic challenges too. So economics favor weak security on first instance. We have information asymmetries, misaligned incentives, and then network externalities. For instance, if somebody hacks your baby cam or like your toaster, the toaster might work perfectly, you have no idea, but some hackers hijacked it and turned it into a part of a botnet attack, botnet DDoS attack. So traditionally, the producers or manufacturers are not incentivized enough because the damages are not incurring upon them. And even not on the user. My baby cam, my toaster is working perfectly. Why would I care to pay for more for a connected device? That's the main thing. So that's where we realized we needed a multidimensional framework to encapsulate the entire system, devices and sensors, apps and platforms, cloud and web services, and a full range of consumer concerns, security, privacy, and life cycle. We have a framework started by our Online Trust Alliance initiative. Please feel free to, I put the link. I'm trying to be quick. 1 minute, just 1 minute. No. 2? Okay, thank you. So this framework is consisted of a total of 40 principles on authentication, encryption, security, updates, privacy, control, communications, developed through a consensus-driven multi-stakeholder process with input from the industry and from policymakers, based on the principle of a user-centric IoT and based on collective responsibility for shared interests for all parties involved. So security includes devices and sensors, applications and services, data privacy principles for transparency and notice, for choice and control and consent, and for sustainability. So this framework, specifically designed for consumer IoT, stands apart from other IoT-related frameworks with its comprehensive focus on security, privacy, and life cycle issues. For instance, how to hand over a smart home or what to do when software upgrades are no longer available for a long-lived device, such as a garage door opener, are included. Most frameworks focus on just the devices, but a system is, as I said earlier, is only as strong as its weakest link. So what we are trying to do with the campaign, as I said, we have to work together, so we're working with manufacturers to make them publicly commit to this framework. I cannot name names now, but we are in the process of signing some big players. And we are working with governments and policymakers to make sure that they come up with smart policies which give some flexibility. For example, privacy by design, privacy by default. Who is going to set the standards of default privacy? So this also needs a collaborative approach for the implementation of GDPR. So we need flexible solutions that will be technology-proof. And most importantly, last but not least, we're trying to work with consumers, because in the consumer IoT market, consumers are not always willing to pay more, but we have to raise awareness and we have to shift consumer demand so that there is actual demand coming from the consumers to incentivize the manufacturers and suppliers of consumer-grade IoT devices to actually invest in better IoT security and privacy embedded from the start, and to build trust on the IoT ecosystem as a whole. Thank you. Okay. Thank you very much.
We have time for questions, Leila? 10 minutes? Oh, great. We have the first question.
Thank you for the wonderful initiative of the Internet Society. I'm looking at the Online Trust Alliance thing, and one of the things that you have on there is a smart home checklist, and it says maximizing security, privacy, and personal safety prior to occupancy or closing of a house. I presume there's a whole checklist. And it says, I mean, obtain a list or inventory of all connected devices. I'm thinking myself, do I have that list? Can I find all the stuff that we have? And then review privacy and data sharing policies of all devices and services. Aren't we placing the burden on the wrong party here? Shouldn't we be able to trust as individuals that the stuff that we buy has certain security properties, etc.? I mean, I don't want to open my refrigerator and look at a milk carton and then check out whether all sorts of stuff is correct there. I mean, shouldn't we have a fundamental shift in, you said in your closing remarks that consumers have to push manufacturers to change their devices. Shouldn't we simply regulate here?
Regulate. Yeah, regulation.
Sanctions.
Yeah, so it's the checklists you mentioned are mainly for, again, a tool for raising awareness. If you check the full principles, you can see that the burden is really quite heavily on the manufacturers themselves. But there are checklists for enterprises, checklists for smart homes, smart offices. Regulation is, I mean, I'm a lawyer. I have a reflex to come up with regulation as a solution for everything. But again, the same thing goes, how are you going to implement? We have to address to the core of the issue, and I think collaboration here is really key. We have to work together. Because regulation, as I mentioned, especially when it comes to IoT, industry is very worried. There are various interpretations of this whole e-communications privacy regulations, whether machine-to-machine, non-personal data is going to be included, is going to be subject to the communication, which brings higher standards than e-communications privacy services. So regulation is nice, so that's why I specifically said smart regulation. I don't like to say smart devices, but I like to say smart regulation. Regulation is a good way to incentivize the market players, but again, when you shift consumer demand and you actually come up with consumers willing to pay more, I still think that's a bigger market force. I mean, at least on the consumer IoT market.
So can we have privacy and security as a marketing strategy for the companies? I mean, if the customers are, so that's what you mean, right?
To make it as a competitive advantage.
Exactly. So
but you can only do that with the demand.
Demand. So the customer should be more knowledgeable. They should be educated, and
Yeah. We have made a partnership with Consumers International recently, the biggest consumer NGO in the world. So fingers crossed.
Okay, great.
We have a year to go.
So, any further questions? I think we have some more time. Do you have questions to each other?
So, I have a question for you, because I was quite interested in the model you were sketching, like the graph and also the threats, and I was curious. So, if you look at the severity of the threats here, so maybe it's a more technical question, but how do you assess that, especially as you say, like you're not only dealing with identification threats, but inference threats. So there's a lot of uncertainty in kind of what you can infer now and what you think you might be inferring from data in the future, and thus putting that in a model to then look at the severity of a threat. I'm curious to how that would work, how you do it actually.
That's exactly right, and that is the motivation for formal privacy models like differential privacy, the need to protect against unforeseen threats that may emerge in the future. So formal privacy models provide a guarantee of privacy that protects individuals in the data regardless of what information may be available from external sources, regardless of the type of attack that may be used. And that's why differential privacy plays such a prominent role in the Harvard Privacy Tools Project and in many of our policy recommendations, because it provides such a strong privacy guarantee in the face of unknown future threats.
And the role of context, do you kind of, because in order for a threat to be severe, that can often be very context sensitive. So is that kind of also taken aboard in that modeling, the use case modeling, for instance?
It can be taken into account in making the decision whether to use something as strong as differential privacy or whether an alternative framework would better protect against the particular threats in a given context. But what's useful about differential privacy, one of its features is that you don't have to carry out such a risk modeling where you take into account contextual factors and things like that. So if you are not sure what the threats would be, a formal privacy model may be the solution for you.
Thank you.
I have a question to you, because you've been talking about differential privacy, and I work on differential privacy, and there's a lot of criticism for differential privacy because of the utility. I mean, it doesn't provide positive sum. I mean, if you publish the data or if you let users query your data and the results are differentially private, then the utility, you may really suffer from utility. For example, I may ask the average age of the people here in a differential private manner. I may have an almost correct answer with high probability, but with a maybe low probability, I'll have a totally wrong answer. And in critical applications like health and similar applications, this can be a real problem. And so do you have anything to say about that?
It's the fundamental law of information recovery that if you run many analyses on data with too much accuracy, the results are blatantly non-private, and this is something that's unavoidable, that as you run analyses on the data of data subjects many times, there is significant privacy loss. And in order to provide protection for individuals, you need to add noise to the data, which reduces utility. And any privacy technique is going to reduce utility. Differential privacy aims to provide the best trade-off between privacy and utility. In many cases where the data sets are large and contain information about a large number of individuals, then you can compute statistics that have very little noise added. In some cases, they're practically indistinguishable from analyses that haven't been run using differential privacy. And the algorithms and the theory are being developed over time, and the accuracy and the utility is improving over time.
Just a small comment, short comment actually. For example, Apple announced that they're going to collect their IoT device data with differential privacy, but differential privacy has parameters. For example, this epsilon parameter, and they said they're going to use like maybe 100, I don't know exactly, but with 100 epsilon, you almost have no privacy. And you know, we should be really careful about that. I guess if there are no further questions, we can close the session. Thanks to all speakers for all those great presentations again. And I think we'll have a coffee break now. Thank you.